So I mentioned it's not just an idea, it's the fruit of creativity. You have to do something to bring your idea towards fruition. Then you get these exclusive rights. Um, that IP deal works for technology or cultural advancements. In the context of branding, right? It's about protecting reputation and protecting consumers, and we'll talk about that a little bit more. The rights are territorial, meaning that they are typically national in scope. So you need to keep that in mind, and we have a couple slides down the line here which address that and when you should address that, because a lot of the immigrants or first or second generation Latinx clientele may want to get the rights here in the United States and not think about the fact that they're manufacturing in Mexico or that in their home country, or that they're going to be selling there or something of that nature. In the United States, sometimes these rights are automatic and you don't necessarily need to obtain registrations. Yeah, I just said that, you don't necessarily need to obtain registrations, and a lot of businesses won't. There are really good reasons to do it, and having a conversation with a trusted lawyer, Tannia, as an example, would be a great way to help you figure out whether you need it, how much you need, and it's really about aligning. Um, so timing can have an important impact. Some rights you cannot pursue if you don't pursue them right up front or within a year. So you need to be mindful and come to people like us early to talk about what protections you or your clients might need. And I think the other parts of the slide I'm going to leave off in the interest of time. Okay, Tanya, I'm still moving forward fast.
Yep. Yes.
Right, different kinds of IP. Key ones we're talking about here are trademarks, copyrights, and patents and trade secrets. Trademarks is about really reputation and the source of the brand, how people associate the product with the provider. Copyrights are about the works you create, which are expressive but don't have to necessarily be artistic. Patents and trade secrets are often about inventions and designs, or things that you're capable of keeping secret, and how those are protected. There are some related concepts that come up. Personal names, images, and likenesses. There are different types of rights that can be associated with that. That means like the person's name or their picture. As an example, the business name or trade name. Domain names. A lot of people have a misperception. Usually the first thing they'll say is, oh, I went and registered the domain name. I'm like, great, but did you register the trademark? Oh, I didn't think to do that. I thought I reserved my rights when I reserved the domain name. Domain name doesn't give you rights, it gives you access. Social media username, same thing. And that takes us to cultural contexts in intellectual property and business. And we talked a little bit about different ways in which a Latinx client might have intellectual property tied into their Latinx, heritage or, who they are. So we said, hey, maybe it's the nature of their goods or services, or maybe it's the word or how it's interpreted, or maybe it's the art and the way in which they express themselves, either in language or in culture and what it conveys. Also, there's Latinx specific designs and inventions may be intended to serve the community in a particular way, or serve things that are common in a particular community. And then there's kind of a culture of not seeking to protect, for inventions, as to why there's a very small number of Latinx patentees, as an example, in the US.